Hi, everybody. Welcome to Spartan Investment Group's First Friday presentation. This is our community building event, both in person and online. We're kind of the mission of this event is to just help folks get accustomed to who Spartan is, provide a forum to ask questions. The whole process of understanding and evaluating what risk you may be exposed to, and then learn how to put risk to work for you. That's part of the mission of our First Friday event. I'd like to start, before we introduce our superstar speaker, I'd like to start and just give you a little bit of context about who Spartan is. Spartan is in the self-storage syndication business. Kind of think of us as a private equity firm. We are the nation's 40th largest self-storage operator. As of today, we have raised roughly $200 million of equity. We have about 110 employees. I keep chasing that number, and it's hard to get it right because we keep hiring people. So I may be wrong on that, but I'm going to be within a tee-shot of the right number. And currently we own 67 properties across the country, several here in the Pacific Northwest, a handful in Texas, and a handful in the Southeast, where, boy, demographics, tax rate, and corporation growth is really booming. The securities that we issue are available for investment by investors, generally by accredited investors. It's a substitute for a publicly traded security, such as your favorite stock, bond, or mutual fund. And I want to really encourage you to take a do-it-yourself approach for a moment here. Last year, the investor relations team spent a fair amount of time developing an Excel file that has macros or programs running inside of it. And this Excel file can help you plan and organize your portfolio of private investments. So what does that really mean? You get 3, 4, or 10 private investments going. You've got your industrial, your multifamily, your self-storage, what have you, maybe a few business investments that are also 506C or 506B exempt securities. And as those securities start paying you, it's kind of hard to keep track of who's on track, who's overperforming, who's underperforming, who's your contact, how much bonus depreciation did you get, et cetera, et cetera. So the portfolio tracking tool that Spartan built last year, I would really encourage you to consider using that tool at home, on your own, on your PC. It's not a software program that lives on our server. It's for your use and education. It helps to organize your cash flow. A good rule of thumb, back in my days at Merrill Lynch, a good rule of thumb is your age with a percent sign behind it. And that's the percentage of your net worth that might be oriented towards fixed income securities. Now, the last decade, we've had an aberration by way of interest rates tumbling lower. And so the whole private investment world has emerged as a bond surrogate, so to speak. And so the portfolio tracker helps you track your maturity, industry, contact person, security specifics, etc. So feel free to reach out to me for the tracker. It's free. We don't track you. See what I did there? But it's really for your use and education. And then as you hear security specifics from sponsors just around, you can start to plug it in and see, okay, well, how much income am I generating in my portfolio? That's a convenient segue. Spartan is very excited about the 3 funds that we are launching in March of this year. And from a risk perspective, the orientation is we want to have the whole playing field covered. So our debt fund will pay 8% per year, and in some situations, the investor will receive roughly 9% per year. There's some nuances coming. We don't have all the details ironed out yet. So that's on the conservative side. A moderate risk type of investment will be our income fund, which is very similar to what we did last year with Storage Fund 1. These are existing self-storage assets that are producing revenue, paying income to the equity investor with the preferred return, very attractive. On the other side of the spectrum, the growth portfolio, this is going to be a purely land development play where there's no income to the investor, but the equity multiple and the IRR will range on the very high end of the spectrum. There's no liquidity in the moderate and aggressive risk funds that I just mentioned. But bear in mind, the debt fund will have a liquidity option and more details to follow. So as you, either with Spartan's portfolio tracker or on your own Excel spreadsheet or with pen and paper, as you plan your year for 2023, do keep in mind that we are launching 3 funds next month. For those that are watching online, either today or over the next couple of weeks, feel free to use the QR code to register to learn more about the funds that we will be launching. And we are pretty excited. Okay, next month, before Shreya, next month, we're going to have a conversation around 1031 exchanges. Our guest is going to be an investment advisor who works for a registered investment advisor. You can find this group at insight1031.com. These folks only do 1031 exchanges. They do some quant and other types of asset management, but their primary business is 1031 exchanges. And the reason I belabored and hovered over the investment advisor and the registered investment advisory, those are fiduciary responsibilities. So in other words, these people have errors and omission insurance because they are required to do what's in your best interest. So if you're active investor and you have wondered about 1031 exchanges, be sure to come back next month because it's going to be very interesting. Okay, now to our superstar. We are joined today by a Pacific Northwester, sweet young gal who is the most outrageous mountaineer, and I'm joking, Shreya. So Shreya is an attorney, and we're going to be talking today about asset protection. Shreya, can you tell us just something fun about yourself that has nothing to do with law or responsible things, but give us something fun and interesting.
I have one Washington volcano left to summit. It's Glacier Peak, and I plan to do that this summer. Otherwise, I've done all the other 4 Washington volcanoes. And so that's my exciting thing that I'm working towards this summer.
Okay, so that's you surprised me, number one. Number two, how long does it, is that like a 2 or 3 day trip or how?
So you can do it in 2 days, like one overnight, but I would like to do it in 2 nights because it's a 35-mile approach. And so it's a very long hike. Yeah. And I don't want to have a sufferfest. So yeah. I'd like to break it up into 2 nights.
And I'm guessing your pack, I mean, how heavy is your pack? Is that 50 or 60? I mean, you're carrying food and water.
Yeah, food, some water, crampons usually, and some ropes. Glacier Peak isn't super technical. So if you go later in the season, there might not be any snow, but you're carrying a lot of stuff. I have gotten my pack down to be relatively small. I think it's probably 40 pounds, 30 or 40 pounds.
What I hear is that you're a normal, approachable person that anybody should feel comfortable talking to.
Yes.
Okay. That's where I wanted to get to. And we're doing great so far.
Yeah.
Okay. Well, tell us a little bit about your firm and what your firm does.
So our firm's pretty boutique. It's me and my husband. We've owned it for 10 years now. We focus pretty much exclusively on helping people protect themselves from lawsuits using trusts and LLCs. and also plan for what happens after they die. And so that is what we've kind of just done for all of our clients. We don't take on too many clients per month, probably, between 4 to 6 new clients a month. And so when people call and have questions, they're talking to us and can get through to us, and we help them send documents to their lender or their investment group and make sure things are titled properly and all of that good stuff.
So that's a good segue. So 53, husband, father of 2. My oldest is a senior in high school. I'm sorry, my youngest is a senior in high school. My oldest is a sophomore in college. So when Mason was born in 2003, we had the will created, the durable power of attorney, the healthcare directive, and pro tip from someone in financial services: if you have power of attorney over somebody's asset accounts, before you need to rely on that document, be sure you go to the financial institution and pull their power of attorney and get it completed so that it's streamlined. I could give you a lot of hairy, scary, detailed information, but just know that that's the case. It's good to have a POA from the law firm, but also work with the financial institution's POA. Okay, so anyway, so Melissa and I that's what we have. So let's start there. How does somebody know when just having an estate plan isn't enough and asset protection is now the threshold that they need to engage with?
I think for a lot of people, it's if this is keeping you up at night, then something to think about. Most of our clients are worriers. They're very similar profile to you in that they have a partner, they might have kids, and they're worriers. They have their umbrella insurance sorted out and maybe they've maxed it out. But they still feel exposed. But in general, our clients are, a lot of times they're licensed professionals or business owners. They have investments that they own, either like not necessarily just in syndications or in a group, but single family homes or multifamily properties that they have either in their own name. And so if something goes wrong in one of those properties or investments, their entire net worth is kind of exposed. And so, I'd say it's pretty normal group, but typically it's people who have accumulated enough to feel a little bit worried when they hear stories of someone else going through a lawsuit. They're like, oh, maybe I should do something.
So let's poke around on that for a minute. So a minute ago, you mentioned they may be licensed or they may be worried about litigation. So how would professional occupational risk, how can that bleed into my personal life?
Yeah. Well, so there's different aspects of it. There's the real estate investor side, and then there is the business owner side, and then there is the licensed professional side. So most of the time when you're a licensed professional, you can't truly limit your liability. And you might have malpractice insurance or errors and omissions, but if something goes wrong or someone is upset, they could sue you, and then they could also say that you have personal liability for the things that occurred because you're the licensed professional, you've signed off on something. And so a attorney representing the other side might also see it as an opportunity, especially if they look you up and they see that you own a bunch of stuff, as a way to maybe put pressure on you personally to settle for something more favorable. And most people don't like the process of going through a lawsuit. They feel a lot of pressure. It feels, it takes a lot of time and emotional energy. So they would much rather just pay these people to make them go away, especially if they don't feel like they have any leverage in the situation, than fight it. And so, that is how it can go on the professional liability side. As a business owner, sometimes you have employees, you have things you're doing with your business. And again, and it's kind of the same with real estate investing. There's this inside liability, which is something that happens inside of your business, but people can also attach outside liability to these business claims, which would be like, not only are you responsible as a business, but maybe the owners of the business are also responsible for the wrongdoings that are alleged.
Good. And so, and somewhere in there, the tenant may view the owner or the landlord as a potential, target for a suit. So,
right, yeah, it's both a strategy that attorneys can use to put pressure on the person they're suing, because attorneys are expensive, especially if you're trying to defend yourself from a lawsuit. For instance, I was a brand new attorney, and I was doing business law and intellectual property, and I had filed trademarks for a client. My client, he went to a conference, and these people approached him, and they were like, "We really like your branding. We know that you're just in Washington. Can we also use the same business name?" And he said no, because he had no plans to just stay in Washington. And also, why would he go through the trouble of protecting himself to allow that? Well, the people who approached him, they did it anyway, right? They started a business, same name, put their website up, started selling stuff. And so I shut their website down, and they got mad. They were so mad. There was no merit to it, but they sued our client. They sued me, and and everyone we talked to was like, "Oh, this is so unheard of." But, they did it anyway. It all got dismissed before a judge even saw anything, like before the summary judgment was filed, because they dropped the lawsuit because they realized it wasn't going anywhere. But between me and my client, we spent $60,000 in legal fees just to get to that point. So it can be really expensive. And so, people want to avoid that. And so they might be like, instead of continuing to pay this defense attorney, I'm just going to pay you $50,000 and go away.
Yeah. And if the back door is open, so to speak, and if there is an exposure to risk, you want to be sure your hatches are buttoned down, or whatever the analogy is. Okay. So the notion of a revocable trust, as opposed to, let's just focus on a revocable trust. What are the characteristic pros and cons? Maybe flesh that out just a little bit.
Yeah, definitely. I think it's important to distinguish between asset protection and estate planning. Estate planning is what happens to my stuff after I die. And sometimes also, if I can't speak for myself, that is the power of attorney. And asset protection is, how do I protect myself while I'm alive? And the two things can overlap, but they are not necessarily the same. So a revocable living trust, its function is, how do I protect myself, or how do I pass things on after I die? It's really no different from you owning something personally during your lifetime. But after you die, it becomes active in a way. It can divide into irrevocable trusts. It can help optimize for estate taxes if you need that. It can do a bunch of different things. But while you're alive, it's really no different from owning something in your own name. It doesn't provide you with any protection. And that can be fine. It has a bunch of other benefits. If you own property in a bunch of different states, it reduces the need for probate, which is up there now. And if you don't know what probate is, my husband likes to say that it's a lawsuit you file against yourself with your own money after you die. Because essentially, if you have a will or you don't have a will and you don't have a trust involved, the will is written for a judge to know what to do with your things. And so they freeze all your assets. They say, if this person owes anyone money, come forward and make a claim against the estate. And they allow creditors a certain amount of time to come forward. And then after that, they will distribute assets to the people named in the will. Washington is considered a probate-friendly state, and they say it takes on average 6 to 8 months. Back when we were doing probate, we don't anymore, but we've had a very simple probate. Like grandma had a house and that was it. Took 2 years to get through it just because people are grieving, have lives, they're trying to also clean out grandma's house. Yeah. And so they can't get paperwork necessarily on time. But then there was this like creditor, grandma owed someone money 25 years ago, and they came forward and they were like, it's been accumulating interest. And this like $800, bill is now $12,000, I think is what they were saying, because we've just been sitting on this. So it was a whole process.
Yeah. So now, for those of you here and those of you watching online, I can tell that Shreya would make a good quarterback because I jumped ahead a couple of questions, and you've done a good job calling it audible and kind of weaving the conversation together to fill in the gaps. So thank you for that.
Yeah, no problem.
And if we spend just a moment on probate, and I think you alluded to this, probate looks different depending on the state that you're in.
Correct. And so if you own, this is part of the benefit of having a trust, is that if you own property, let's say, or have bank accounts in multiple states, you would have to open a probate in every state that you own property, most likely, even if it's a small probate, if you don't have a trust. And so without having a structure in place, it can get very messy and very expensive. And probate looks different in every state. You can't have just one attorney represent you. That attorney has to then work with an attorney in California or Montana or wherever to then handle the probate in that other state. And so, it gets messy.
So how is it handled if the estate is short on cash but has heavy expenses to work through this? I mean, to me, that sounds like that's $20,000 easy to.
Yeah, it's really difficult because then the people you've left behind, they may have to pay for it out of pocket as opposed to from the estate. And you can avoid probate by having a trust, a revocable living trust even, and putting things into the trust. And so when you first create a trust, it's like an empty backpack. And then throughout your lifetime, you can put things into it and you can take things out of it. And you can title things to, flow through the trust. And so it simplifies things by eliminating the need for probate. For the most part, it can become optional. And making it less expensive.
And then... And I'm reflecting back. I used to know a little bit about this, and my memory is diminished just a little bit. But there's the one-time gifting or the exercise of the unified credit. Does it matter if you're dealing with a simple will, the way Melissa and I are, versus a living trust that is generally revocable?
Yeah. So most estate planning trusts that people create are revocable living trusts. Things you put into the trust are not a gift in that case. So they are still considered a part of your estate. When you're gifting something, that's most likely an irrevocable trust. And an irrevocable trust, it does not mean that it's completely unchangeable, but it does mean that there are certain provisions in there that can't be changed. When in the estate planning context, an irrevocable trust is often a gift. So you're gifting something out of your estate. It won't be considered a part of your estate after you die. There's pros and cons to that people need to consider because, yes, you may be gifting something and it reduces your estate tax burden, but you're also a lot of times gifting the basis of that asset. So if you have a very low basis and then you gift it away, the people you're gifting it to when they go to sell it, might have a much larger capital gains. But that's getting like very complicated. Yeah. The point is there's this irrevocable trust. There are different types of irrevocable trusts. And the one that people use for estate planning is usually this one where you're gifting things away. There are other types of irrevocable trusts, ones that we create for people called asset protection trusts. Those are irrevocable, but it's an incomplete gift. So they're considered defective, intentionally defective.
Okay. So I'm going to jump ahead on, I'm going to catch up here. Okay. So now let me just poke around a little bit more on this topic. So if an investor wants to streamline the process at end of life or after they've passed by using a trust structure as opposed to the simple will, which complexity, and especially if you've got properties in 5, 6, or 7 states, that's just a mess. So does having a trust make the process of gifting or sharing, if you're an active investor and you've got, let's say you've got a duplex, in some other state than where you live, versus a simple will versus a trust, how much more complex is it? And I'm focusing on the notion of putting things into the backpack.
Yeah. It's not that complex.
Okay.
It's a simple filing a deed to have the title reflect the trust. And for the most part, I would recommend people just hire someone, an attorney, title company, paralegal, to complete those documents for you so that you know it's done properly. But I know a lot of real estate investors are very comfortable drafting deeds and filing them. And so some people have done it themselves as well.
Yeah. Okay. So let's move to the difference between revocable and irrevocable. I don't know why I said that. Is there anything on that topic that you want to shine a flashlight on that people should be aware of?
So a irrevocable trust provides you with protection during your lifetime. Any type does, whether you want to gift it out of your estate or not. Revocable trust does not. The kind where you're gifting something away will, the issue is you can't get it back. So most of our clients, they're still growing their wealth. They want access to their assets. They don't want to give something away. They're not at that stage in their life. And so for them, the type of irrevocable trust where you're gifting something out of your estate is not attractive to them. So they want something like an asset protection trust where it's intentionally defective. It's not being gifted out of their estate, but it still provides them with protection because of the way that it's drafted and because there are certain parts of it that can't be changed. And I think from a management standpoint, it's a little bit harder to manage the irrevocable trust. You definitely want people on your team, if you have that kind of trust, to help answer questions, help figure out what can go in it and what cannot. That's not something you could ever do on your own.
Yeah. Okay. By the way, for those of you online, if you have a question, either that you brought to the table today or that contingent on something that Shreya has said, feel free to, in the chat box, type the question. Our main man, Roy, is going to add those questions to, he'll send those to me. And as we get to the end here, we'll run through some questions either online or folks in person. And by the way, let's wait till the end on questions, as people online can't hear your questions. So I'll repeat, and et cetera, et cetera. It'll just work a little more smoothly. Okay, so we've got this chart.
Yes.
Tell us all about it.
So oftentimes when people call in, they want to know if I have an asset protection plan and I have my estate plan, it's a revocable living trust. How are the two going to work together? Can I have both things? And the answer is yes. And this is an example of like a fully formed asset protection plan plus estate plan for somebody. And essentially, you have your assets that you've invested in LLCs or LLPs, depending on what kind of asset it is. It's owned by a holding company. And this helps streamline things. So it brings all of your assets together into one kind of umbrella. And then typically the next step up from that for people is they add a asset protection trust to own the holding company and own their personal assets. And so this helps protect them from the outside and the inside. We talked about outside liability a little bit, with the professional liability and how people will sue you personally as well as in your business. But outside liability can even be something like a divorce. It can be a car accident. Car accident and divorce are probably way more common than something happening inside of your investments. And so this protects against that, your personal assets from that as well. And then you pass away. So what happens to your stuff? What happens to this asset protection trust? You already have a revocable living trust. The asset protection trust just says, follow the instructions in their estate plan. And the estate plan distributes things the way that you want them distributed. And kind of the benefit too of having both an asset protection trust and a revocable living trust is with asset protection, you're trying to benefit from the best jurisdiction that's going to provide you with protection. So when people create a holding company, they're creating it in Nevada or Wyoming, and you don't live in Nevada or Wyoming. And so you want an estate plan that's going to focus on optimizing for your state. And also a lot of times you might have young kids, right? Yep. And you want to name someone to be trustee that's going to take care of your kids and take care of the money for your kids. And so a revocable living trust can have a lot more color to it that can help in that after death scenario on what to do and how to divvy things up.
But I reflect back on myself when I was in my 20s and my 30s, and from all outward appearance, I had a professional job and a stable life. Mm-hmm. I didn't have the chops by way of, I'd like to think that I'm fairly seasoned as an investor. Mm-hmm. For a mom or a dad who want to have some loving protection for their kids who are still in their 20s or 30s and are mm-hmm. eventually going to receive some assets. How do you do that with it? What does that look like? How would Melissa and I keep Mason and Amelia on the straight and narrow, mm-hmm. but eventually give them the bucks? How does that work?
So you can do that through your revocable living trust. You can set up mini trusts. So it would say that when I die, my husband gets a certain pot of money and then the kids each get a certain pot as well. So it can split into several trusts. And then you can create something like lifetime asset protection trusts for the kids. And so the money that you give to them can be held in these little pots that can be managed by somebody else. Okay. Until they reach a certain age. And then it can stay in that trust and they could become managers of it at a certain point of time and still be protected. We had a client whose parent had created an asset protection trust for them. And, she got in a terrible car accident. They got sued. She was fine, but they got sued and the people weren't happy with what insurance was offering them. And so they sued our client for, I think it was 7 figures above and beyond what insurance was offering. And before she kind of realized what she had with this asset protection trust, she was like, do I have to file for bankruptcy? What am I going to do? There's no way I can afford this situation or this type of settlement. Yeah. And because her parent had provided an asset protection trust through this revocable living trust for her, she was instead able to settle for like $50,000 because they couldn't touch this inheritance that she had been given.
That is a significant, that's astounding.
Yeah.
Good for her. Okay, so why would I need, if I have LLCs currently, and by the way, my experience with LLCs is they're a real pain in the neck because you've got state filing requirements annually, and like California, what a bugger California is. I mean,
yes,
that's a hassle. So if I have LLCs, what's the advantage of a trust versus the LLC?
Yeah. Well, so they do different things. The LLC, you're trying to put boxes around each of your assets with the LLC. And the trust does something different. It helps with that whole what happens after I die scenario. If it's a revocable living trust or focused on estate planning, if it's an asset protection trust, it can give you options. So sometimes you have a state like California that charges the $800 per year minimum franchise tax for an LLC. You don't want to put these assets into an LLC. And so instead you can create like these mini asset protection trusts for each property. You also might have a lender who does not want you to be able to transfer a property from your name to an LLC, but they have to allow you to transfer it to certain types of trusts. Not every type, but grantor, we work with people to make sure that it complies, but they have to allow the trust by federal law.
So if we drill down on that just a little bit more, so if someone were to create a trust, does everything, including all the cars, need to go into the trust, or how inconvenient is this whole bite that some of us will take eventually? Tell me about that.
No, not everything needs to go into it. You can pick and choose what goes into the trust. We typically recommend that the bigger assets go in, or savings accounts. You can name the trust as a beneficiary instead of putting things into the trust. And so that means that, if something happens to me, then the trust gets the money. But it can be as, I guess, complicated or not as you want. And definitely things like cars or boats don't go into a trust unless it's something like a classic car. Like, if you're, I guess, Jerry Seinfeld and collecting classic Porsches, you might have some of those in entities. But otherwise, for everybody else, cars create a lot of liability. We buy new cars all the time. It's going to mess up your car insurance. You just leave that out and it's fine.
So what if an investor has a newly created revocable trust, but they also have securities, and when those private securities were purchased, the individual was the owner of the investment and not the trust? Does the investor just let those securities mature and then move the cash into the trust? And if the security is retitled in the name of the trust, is that a taxable event? I don't think so, but
it's not for a revocable living trust because the tax ID for a revocable living trust is your social security number. It's the same as though you own it. For most of the time, though, for securities, you're naming a beneficiary as opposed to moving them into a revocable living trust. And then, just waiting until it matures, maybe you move the cash in. But for most securities, bank accounts, you have the option of naming a beneficiary, and you would just name your trust as the beneficiary.
I could go on and on, but for the sake of time, let's jump to the topic of LLCs. And LLCs are very common, as I'm sure most folks here are aware. What if somebody has one LLC, but investments in various states? Shed some light on that.
Well, you can do that, but like I said, the idea behind creating an LLC is that you're putting a box around each asset. So depending on how much that asset is worth to you, it may be worthwhile to separate that asset from other assets that you own. So putting boxes around each of them means that if something stops at that inside liability, someone trips and falls, someone leaves a faucet on and creates mold and then gets sick, it's limited to what's inside of that LLC, hopefully, because you've done other planning on the personal side, so they don't want to go after you personally. And so it doesn't infect all the other assets that you own. So there's that aspect of it that, it's kind of just a good idea. And depending on your risk tolerance and how much you've invested to limit one asset per LLC. But with different states too, you're going to have to end up registering that. So people a lot of times will do it because they want to save money on the annual requirements and filing fees. But you're going to have to register that LLC in each of those states anyway. At least you're supposed to. And so it doesn't actually end up saving you any money to have just one LLC registered in multiple states.
Oh, that's interesting.
Yeah.
Okay. So what if I have an asset and a mortgage? What does it look like to transfer that? And then layer on top of that, the LLC topic.
Yeah. So most trusts, at least most of the trusts that people create, you can transfer the title of the property into the trust. So I like to separate it out for people because there is the ownership of the property. So this is the title of the property. And then there's the mortgage. And those are somewhat separate things. You're not transferring your mortgage to an LLC or to a trust. You're still the person borrowing the money. Sorry, I just hit the microphone. You're still the person borrowing the money. You're just transferring the title of the property into a trust or LLC. Some lenders do not want you to transfer your property into an LLC. They're worried that they're never going to get paid back or they're losing their security on the loan. And so in that case, it's fine to transfer it into the majority or most types of trusts. You definitely need to check with your attorney to make sure it's the right type of trust. But by federal law, they have to allow you to transfer it to like a revocable living trust. And they can't really say anything about it. We tell most of our clients, like, you don't really even need to tell them because they might get confused. But if it's like a revocable living trust, it's fine. You're not trying to transfer the mortgage or change it in any way. If you transfer to an LLC without asking your lender, and then they have a policy that you're not allowed to do that, they could potentially call the loan due and force you to refinance. Yep. I mostly see it happen when someone's trying to do a cash out refinance or get a HELOC or something like that on a property. And then the lender's like, but wait, this isn't in your name anymore. Yep. And then they get upset. Yep.
Okay, so just another reminder. We do have the opportunity for questions for Shreya. We've got a couple that have come in. Feel free to type those into the chat, and Roy will pipe those up. Let's finish with just two more pre-planned questions, then we'll go to questions. So tell me about LegalZoom, and is it thumbs up, thumbs down?
For certain things, LegalZoom is okay. And it depends also on how much you have at risk. So if I'm just starting out and there's not that much that is at risk with something, maybe I form an LLC or get my estate plan through a LegalZoom type of service like Online Wizard. But with something like an estate plan especially, and asset protection, you don't know if it's going to work until it's too late. So if you're okay with that, then LegalZoom might be all right. But once people start accumulating a little more wealth and having a little bit more in their asset portfolio, it becomes less and less okay. And then when there are other people involved in your life, like you have a partner or you have kids or you have parents you're taking care of, then it also becomes less and less worthwhile. So I would say that, because we get people calling and they're like, well, I can just go online to the Secretary of State and file my LLC. And it's like, yeah, you can, but what about all the other requirements that if that LLC is tested, do you know how to do those? Do you know to get a registered agent and get your business license and have an operating agreement and open your business bank account and get an EIN? And so people, I think, sometimes don't do that follow through. So I think there's that aspect of it. If you're going anywhere near an asset protection plan and asset protection trust, you cannot use LegalZoom. You cannot use an online wizard. I would not recommend it. You need other people involved. It's more complicated. You will lose the privacy that you're wanting, all of that stuff.
Gotcha. Okay.
Yeah.
By the way, Roy is reminding me that I misspoke and that questions should go to the question box, not into the chat, for those of you watching online. Okay, one last question. Tell me about an executor. How big of a deal is that? And, what's the bottom line there?
When you're naming someone to be in charge of your estate after you've died, you want someone who's going to be very organized. There is some work involved. They don't have to do it alone. They can hire accountants. They can hire, a trustee company. They can hire an attorney to help them. But you just want someone who's organized. It's going to be some amount of work. They're going to have to gather paper together and present it to someone. For something like if you have a will-based plan, it's going to be a little bit more work because they have to deal with the probate process and hiring attorneys for that. For something like a trust, it could be quite simple. If you have things in your trust already, they have to get a, death certificate, take it to the attorney, sign some papers, and then kind of deal with stuff on their own. So it's much simpler process if you have a trust.
If you have a trust. So, dear friends of mine, they're elderly. Mm-hmm. I'm not even sure if they have a trust or not, but I'm their executor. How much time am I looking at? So it'll depend. I would say the majority of time is going to be spent making sure that you know what all their accounts are. Okay.
Not necessarily in some of the other stuff, but knowing what are the accounts, how do I access them?
Yeah.
And so I would say a few hours a week for a month or two, I would devote to that.
Does your firm handle that stuff?
We do not. We refer that out to the professionals.
Yep. Okay, so let's go to some online questions, and we've got a couple here. So we'll grab these online, and then we'll do the folks here in the room if there are any questions. So here we go. Mm-hmm. For assets held in an irrevocable trust, can I defer long-term gains on assets sold if the proceeds are retained and are used for other asset purchases? And if so, when I pass, will my successor trustees receive the assets at a stepped up value?
I don't think I can answer that here. I do not know. I would have to think about it.
Yeah. So if we just kind of unpack that, it seems like there's two questions there. So deferring the gains on the assets sold if the proceeds are kept in the trust, it seems to me like that would be definitely not. I mean, Why would the IRS forgo realization of gains just because?
Typically, I would say no. It might depend on the type of trust, but I can't imagine that they would allow that.
Yeah. And by way of the basis and the step up, are we still doing, back in my years ago, it was you did a date of death valuation, and then you did a subsequent date of death valuation 6 months later, and the estate had the option of picking between the two. Is that still the case?
I believe so. Yeah. I think that's still, it can also, I think, just depend on how long the process is and when you start the kind of administration process and whether you have a trust or not and that type of thing.
Which states are you licensed to practice law in?
Right now, just Washington, but we work with clients on the asset protection side from all over the U.S. Because the asset protection trusts that we create are hybrid onshore, offshore, or offshore trusts. And like I said, with asset protection, you're playing with jurisdictions and trying to find the best jurisdiction that's going to give you the most protection. So we can create, and for Washington clients, we can create LLCs anywhere for them and work on estate plans.
Yeah. What is the typical profile look like for an investor who's working with you from a net worth basis? Is that 2 or 3 million on the low end to a larger number? What does that profile look like?
I think with LLCs, there's a much bigger range. If you're looking at something like an asset protection trust, I'd say people don't start worrying about that until they're at around 2 million in net worth. And up to, I guess on the high end, it's like 20 to 30 million net worth. For most of our clients, I'd say it's within there. And that's looking at something like an asset protection trust where they're putting things in this hybrid onshore offshore trust or looking at a fully offshore trust. The administration costs are high too. So there's that. But if you're looking to create like a holding company with LLCs under it, it may be lower than that, right? And so.
Good.
So, and same with estate planning.
Copy. Yeah. So the next question, does it mean if most of my assets are in cash or invested in securities, I don't really need a trust? Would you agree with that statement? I'm not, there's not a qualifier here for the net worth valuation, but.
I would not. So if you're in Washington state, you have a few things to worry about without a trust. One, you're going to go through probate. If you have more than, I think it's $150,000 in your name when you die. And so if you want to avoid probate, a revocable living trust would be really useful. If you have 2.1 million in your name or higher, you have to worry about the Washington state estate tax. And so a trust can help with that side of things too. And as far as the asset protection, it just depends on what you do for a living and whether it worries you to have a bunch of cash. I mean, if it's all in retirement accounts, you probably don't have to worry. But if you have brokerage accounts and things like that.
And without the trust, you're giving up privacy in probate if you don't have the trust.
Correct.
If you do have the trust, it's discoverable that you've passed, but nobody can pry open the door and see, did Ted have 32 million or 2?
Right. And so when you hear about all these celebrities, you get to hear all about how much money they had and all the different drama going on in their life because they didn't have a will or an estate plan. And so if you don't want people knowing your business after you die, trust helps with that as well.
Copy. Okay, next question. Who owns the asset protection trust? You or your revocable living trust? Also, can you clarify the big difference between those two trusts?
Yes. So an asset protection trust is an irrevocable trust. There are certain things that are unchangeable about it. Also, so a typical trust has 3 roles. It's the person creating the trust, the person managing the trust, and the person benefiting from the trust. In a revocable living trust, you're in all 3 of those roles. Asset protection trusts may have, or irrevocable trusts in general, may have someone, a third party as trustee, so the person managing the trust. So you could be the person creating the trust. You might also be the person benefiting from the trust, but there's someone else managing it. You could also have an irrevocable trust where someone else entirely is the beneficiary. So you're the person creating the trust, you have a third party managing the trust, and you have someone else as beneficiary. For an asset protection trust, you could still be in all 3 of those roles, but there's a 4th role in an asset protection trust called trust protector. And so the trust protector can step in on your behalf if the assets are at risk and change the trustee or change the beneficiaries or move the jurisdiction of the trust or take action to protect the assets more. And so that's what gives it its protective quality. I think the other difference to can you repeat the question?
Yeah. Who owns the asset protection?
Okay, the owning part. Yeah. So in a trust, you don't own the assets anymore. You're managing the assets. So it's an indirect ownership. That's part of the difference between an LLC and a trust. LLC, you still own that LLC interest. With a trust, you don't own it. You're simply benefiting from it. So you're the beneficial owner or have a beneficial interest in the trust. That said, you can still create asset protection trusts where it goes through to your personal tax returns. So it's similar to that revocable living trust in that way. You don't have to ever give up control of the assets, but if you do, it's more protective.
Copy. So I think for our viewers online, we may be getting close to the end of the meeting. Just so that you viewers online know, we will be sending out a replay of this event probably tomorrow morning, Saturday, or as late as Monday morning. So anyway, just know that. Okay, another question. Is it a good idea to set up a trust or LLC structure in preparation for acquisitions of investments and opening LLCs in the upcoming months or years? To word this another way, like instead of investing first and then transferring the assets to the trust later, start with the right asset protection structure and then start investing. And how expensive is it to set something like this up?
Sure.
Good question.
Yeah, good question. So pros and cons. If you set it up ahead of time, you get more privacy because you could potentially close directly into your structure. And so your name is never going to be on a deed or on paperwork for people to follow up on. Con is that, especially in fast markets or very competitive markets, lenders may not want to close into a trust or an LLC. So and to get favorable interest rates, they may require you to close a property into your personal name. And so in those cases, you would have to close into your personal name and then transfer to the LLC or trust. And so those would, I say, be like the pros and cons of that, those two approaches. Of course, setting it up ahead of time, the earlier you set it up, the easier it is to add to it. And I would say it's actually less expensive when you set it up ahead of time in the long run, when you're looking at, 10 years or something, because otherwise you end up with 10 properties. You don't remember how they're titled. You've lost, the paperwork for them, and you're trying to set up this structure and you're having to do all this research and then transfer things in. And it can be a little bit just more expensive to do it after the fact. And then talking about expenses, costs, I would say a typical holding company with LLC underneath structure, you're looking at investing probably like $5,000 or $6,000 for that. For a revocable living trust estate plan, on the low side, for a really simple trust, you are maybe at like around $2,000. They can go up to $6,000 or $7,000 for a revocable living trust. Asset protection trusts are going to be a lot more expensive. You have more people involved. And so I would say anywhere between $10,000 to $50,000 for an asset protection trust, depending on what kind of trust you're getting. A fully offshore Cook Islands trust is going to be like $40,000 to $50,000. And if you're currently being sued, it's going to be more like $100,000 to set up.
Yeah. Okay, last online question that we have. What are the implications of the upcoming Corporate Transparency Act that will affect LLCs beginning in 24?
Yes, that's a great question. So I would say a lot of real estate investors have leaned on LLCs in certain states for privacy. So places like Wyoming, you set up your holding company, they own your LLCs, and you get privacy on who owns the LLC because Wyoming doesn't publish that information online. So it's definitely going to impact that, where you won't have that same level of privacy anymore. There's going to be reporting on ownership of all of these entities.
Interesting. Okay. So we're right at 1:30. We're probably going to lose our online audience. For those of you that are online, you'll receive a recording of this, tomorrow or Monday. Okay. So for folks here in the room, any questions that you might have, and once you've asked the question, I'll repeat it in case the online viewers are still with us, just so they can hear. Sean.
What is your opinion of umbrella policies, and how's your favorite way to utilize them?
Sure. I think they're really important. I think we think of asset protection as a ladder, and the first tier is insurance and making sure you have the proper insurance. And it's a great thing to be able to offer somebody so they don't come after your other assets, right? To say, here, I have this insurance policy. Insurance is going to give you X amount of money. Just take that and don't come after me. And so I would say there is such a thing as too much insurance, but because insurance companies are for-profit companies, if they can find a loophole to not pay out, then they will. That said, it's very important to have that. I just think you shouldn't only rely on insurance for that reason. With umbrella policies, you just have to make sure it covers the activities that you are conducting, right? So if you have short-term rentals or you're Airbnb-ing a property that you own, you want to make sure that your insurance doesn't have an exclusion for that. Or if it does, maybe you keep that insurance and you think about other ways to protect yourself. But I think they're really important. Mostly on the personal side, I know some people do like business umbrella. And we've had less, I guess, exposure to that or seen like benefit for our clients with that. But definitely the personal umbrella, we recommend people get that.
Anybody else with a question? Yes.
You mentioned that like some trust, like one of the issues is that you have to make sure that it's been set up correctly. Would you recommend like having your trust be reviewed by another lawyer after you set it up, so that make sure that nothing has been overlooked? Essentially, like having somebody double check it.
So,
and maybe I'll just repeat that in case our
sure.
audience. So the question had to do with once a trust is established, either by a professional or an individual, at what point does it make sense to have the documents reviewed for accuracy and legitimacy? So,
yeah, I would say it's a touchy subject. I don't think it's necessarily a bad idea, but you're going to find it difficult to find attorneys to do that is the issue. I think, as long as you're going to someone who's licensed and focuses on that area of law, you're most likely going to be fine. And then you can periodically get it reviewed, every 5 years or so, or whenever big life changes happen, you can go in and talk to a new attorney and they'll find that more acceptable. But if you've just set up a trust and you're like, hey, can I send this to you to review? Most attorneys are going to feel apprehensive about doing that. So it's not a bad idea, but it's just kind of a tricky area.
Yes, sir, in the back, and then.
So in the case of an LLC, right, if you are being sued, I heard the term that piercing the wheel.
Mm-hmm.
What does that process look like? I mean, is it easy to do that? I mean,
so
if it's easy, then what is the point?
Yeah, so the question is about piercing the corporate veil with an LLC. So there's a few different things that I think people get confused about with that. One is that, so let's say you have a multi-member LLC. It's going to be much harder for that veil to be pierced than a single member LLC. So that's why people have a preference for multi-member LLCs. And this is multi-member, like not your spouse, right? This is an unrelated party or maybe like a child or parent or something. Those would be considered multi-member, especially in Washington state because we're a community property state. That said, people confuse piercing the corporate veil with outside liability a lot of times. So piercing the corporate veil means that they've sued the LLC. They have found that it's not been properly kept up or managed. And so they go after the owners through the LLC because they're like, this is a sham of an LLC. And so we're going to go after the owners. But what people oftentimes mean is they're talking about this outside liability that we mentioned at the beginning, where they not only sue the LLC, but they sue the owner of the LLC because of the certain claims. So it might be fraud or neglect or other things that attach personal liability to the claim. And so that personal liability is outside liability. So they're coming after you as an individual and then trying to come after the assets in the LLC through you instead of going up through the LLC. That varies from state to state, how much protection you get. So people like Wyoming, because they offer better protection to single member LLCs from outside liability. They say you can't come in and like sell off assets or lay claim to assets within the LLC. You get charging order protection only, which means like anything distributed from the LLC, they can claim, but they can't sell off assets. Washington state doesn't see a difference really between the owner of a single member LLC and the things inside of their assets. And so usually that's what people kind of lump all of that together. This issue with multi-member versus single member, this issue with piercing the corporate veil because you didn't maintain your LLC properly or you used like personal expenses from your LLC account, like you're taking trips to Costco and like buying groceries and whatnot with your LLC. And also this inside and outside liability piece. So they kind of lump all of that together and talk about it as piercing the corporate veil.
So you mentioned something that's interesting, not keeping up. Is that the annual meeting of the members, the documentation that going along with that? How do you?
It's a bunch of different things. It's bookkeeping, keeping the books of the LLC. It's the annual requirements. It's having your registered agent. I mean, for the most of us who are running a business, if an attorney is looking hard enough, they're most likely going to try to find they're going to be able to find something that they think is like lacking in your LLC maintenance and operation. But you can do your best to keep things buttoned up. And that's mostly just treating it like it's separate from you as a person and keeping up with those annual requirements.
So if you have the registered agent, if you do keep, let's just call it books and records that identify what's happening inside the entity, and it's managed in somewhat of a professional manner. You've maintained the integrity of the asset, but if you never do a members meeting, if you never have an annual report, if you're delinquent in filing your tax return for the entity, you might have blown it.
Yes.
Okay. Drew, you had something.
Do you have any opinion on a series LLC, which gives you optimistically kind of gives you the best of both worlds, where you have only one entity, but lots of boxes around different assets?
Yeah, I think series LLCs can be really great. I think they can be potentially a gray area because if you live in a state that doesn't have series LLCs, then someone could argue to collapse the series. So let's say I set up a series LLC in Wyoming, but all my properties are in Washington, which doesn't have a series LLC by statute. I guess the question would be, would Washington apply Washington law or Wyoming law to that? And would they then try to collapse the series? Or do you register each series separately in Washington, in which case you're spending a lot of money. Or the same amount as if you had just created different LLCs for each property.
Maybe a follow-up on that is for both of you, Ted is overseeing Spartan and then Shreya in your capacity as a advisor. What would you say to people that are looking to invest in a syndication and they're asking whether they should invest as an LLC into the syndication, which is almost certainly also an LLC?
Yeah, and maybe I'll just interject before we answer that.
Sure.
After Shreya and I answer this question, we'll say goodbye to those of you online and watch for the recording. The question was, when investors approach either a deal sponsor or counsel with the question of how should I title my investments, my response has been and always will be, unfortunately, we don't provide tax, legal, or investment advice. And so you really want to consult an attorney or an advisor. Syndications
are pretty safe investments. You're investing with a bunch of other people, so you have that multi-member protection. A lot of times, syndications, you're a limited partner. And so I would say whether you invest as an LLC or not can depend on whether you have other types of investments as well. And it makes sense to consolidate everything into a holding company. And so from like an asset protection standpoint, they're relatively safe. And so it doesn't, you can get some added privacy. That would be the only benefit to investing as an LLC. From an organization standpoint, as in like keeping things organized and together, it probably makes sense for a lot of people to invest as an LLC, especially if they're doing like a bunch of different investments.
Yes, sir.
Does hiring a property management firm like offer any kind of protection in these type of cases? Because it can claim that we relinquish some of our responsibilities for what?
Yes, definitely. I'd say that hiring property management companies definitely helps.
Sean, did you have something? Yep.
I guess I think the only disclaimer I would say, it depends what is the arrangement you have
right
with the property manager. I mean, sometimes.
I mean, you can still protect the equity you have in your asset by putting it into an LLC or something like that. But hiring a property management company, the idea is that you're relying on a professional and leaning on them to do the right thing. Now, sometimes they don't, but you have someone to blame for that.
Do I need to sign a contract in order to do this, or like by just hiring the?
I would always recommend signing a contract.
Michael.
I have a question regarding a trust. So, is a trust tied to a state, like an LLC? And in the event if I move to a different state, do I need to do something about it?
Yes, it is tied to a state. The best thing to do is if you move and to update your estate plan to be optimized for that state. That said, a lot of people don't do it. So let's say you move, you never update your revocable living trust, you die, the state is going to honor the estate plan you have as long as it's valid. So it's not, you're not, as long as you've done the planning, you'll most likely be okay, but it won't be drafted for the laws of that state and optimized for that state. With something like an asset protection plan, you're playing with jurisdiction, so it's never going to, for most of our clients, it's not in the state that they live in anyway. And you might have some like offshore elements or different things, so it doesn't matter for that.
In the back, RJ.
If you are a full-time investor and you want to buy properties with the intent of scaling your portfolio, and what you know about LLCs, would you rather start an LLC before you buy your first property or any property, or after you buy a property?
It kind of just depends on our clients and the lender that they have and whether they're going to be allowed to close into the property or not. It may not matter because they may not be allowed to close into the LLC.
Anybody else? We got our money's worth. It's fun.
Yeah, thank you.
Yeah, so Josh has a handout for everybody. Shreya's contact is on the handout. Feel free to reach out to her. And it's fun to have you all here. Thanks for coming, and we'll do it every month and come back.
Yeah.
I like having you here. That's it. Thank you.
Thanks.